Hello, my name is Kelly Chuang, and today I'm going to be speaking to you about the Family and Medical Leave Act. Before I talk to you about what the Family and Medical Leave Act is and who it applies to, I wanted to provide you with some information on why there was a need for such an act to be passed. Previous to the Family and Medical Leave Act, there really wasn't anything in place to protect workers that needed to balance their family and work life. In the past, women were only able to take minimal time off for the birth of their child, and workers received very little, if any, time off to care for ailing family members. Many workers feared of losing their jobs if they wanted or needed to take additional time off for family reasons. This became a growing concern as the percentages of women in the workplace acting as primary support for their family was increasing, and there were many workers with aging family members that needed to be cared for. In 1993, President Clinton signed the Family and Medical Leave Act to serve the purpose of promoting equal employment opportunity for women and men, promoting economic security of families, and serving national interests in preserving family integrity. Now that we've discussed the reasons that FMLA was introduced, I'd like to talk about what employers are required to comply with the FMLA. So there are certain employers that must comply and provide FMLA leave to their employees. These employers include employers in the private sector with 50 or more workers in 20 or more work weeks in either the current or preceding calendar year. This includes a joint employer or successor in interest to a covered employer. Public agencies are also required to provide FMLA. These agencies include federal, state, or local government, and unlike private sector employers, it does not matter how many employees that are employed there. Also, public or private elementary and secondary schools must comply with FMLA regardless of the number of employees that the school employs. So now I'd like to address the major provisions of the FMLA. Under the FMLA, eligible employees of covered employers are entitled to take 12 weeks of unpaid job-protected leave for specific family and medical reasons. Reasons for the leave may include leave for their own serious illness, leave for their birth of a child or adoption of a child, or leave to care for a child, spouse, or parent with a serious health condition. In 2015, a final rule was made to amend the definition of spouse to include lawfully married same-sex spouse. Now, this leave may be taken intermittently or all at one time. Eligible employees must be provided with continuation of group health insurance coverage under the same terms and conditions they had prior to taking leave. Covered employers must ensure that employees are guaranteed the right to return to their previous or equivalent position with no loss of benefits at the end of the leave. There is an exception to this, which I'll cover later in the presentation. Now I'd like to talk about the leave provisions for military. In 2008, the FMLA was amended to include exigency leave and military leave provisions. The amendment provided employees to take up to 12 weeks of unpaid leave during a 12-month period for exigencies arising out of an employee's spouse, child, or parent being on active duty or deployed to a foreign country or called to active duty service as a member of the National Guard or Reserves. Eligible employees are also eligible to take military caregiver leave, which provides up to 26 weeks leave in a 12-month period. This leave is intended for employees to assist in caring for a covered service member who has a serious illness or injury. In 2013, a final rule was put in place for the FMLA to include veterans as a covered service member under the military caregiver provision. Now that I've covered the major provisions of the FMLA, I would like to touch base on a few exceptions to the Act. While covered employers must ensure that employees are guaranteed the right to return to their previous or equivalent position with no loss of benefits at the end of leave, there is a limited exception to certain highly paid employees. An employer may deny restoring an employee's job if that employee is deemed to be a key employee, and returning to that job would mean substantial hardship and grievous economic injury to the operations. Key employees, as defined in CFR Section 825.207, are salaried FMLA-eligible employees who are among the highest paid 10% of all the employees employed by that employer within a 75-mile radius of the employee's worksite. There is also a combined limitation that I wanted to mention, and it's for eligible spouses that work for the same employer. The combined limit leave of 12 weeks for the birth of a child and bonding time, adoption of a child, and the care of a parent with a serious health condition. And there's a combined limit of 26 weeks total leave to care for a covered service member with a serious illness or injury. Now I'd like to talk about implications of noncompliance with the FMLA. There are two types of complaints that an employee can make against an employer for noncompliance of FMLA. They are interference and retaliation. When an employee makes a complaint against an employer in respect to violation of FMLA, the Wage and Hour Division investigates that complaint. If the complaint cannot be resolved by the U.S. Department of Labor may bring action in court to force compliance. If an employer is found to have violated the FMLA, not only may they be liable for the employee's compensation and benefits lost through that particular violation, they also may be liable for other relief, including reinstatement or even promotion. Employees may also bring private civil action against the employer. Now I'd like to talk about the effect of other state regulations on the FMLA. Many states have their own leave requirements which may reflect the FMLA. As of February 2016, there were a total of 19 states, along with the District of Columbia, that provided leaves that were more expansive than the FMLA. These state laws either increase the amount of unpaid leave when an employee can take, or increase the number of people who can access the FMLA by changing the eligibility requirements. Covered employers are required to follow the provisions of the state the employee works in. So an example of this would be with FMLA. Under FMLA, employers can require that paid leave be substituted. But there are some state laws that stipulate the employee has the choice. They must be given the choice on this. If there are state laws that are in effect during an employee's leave, both the federal and state laws must be evaluated separately, and the law that is more advantageous to the employee must be applied as FMLA sets the minimum standard. Now I'd like to discuss two cases that occurred because of an employer's non-compliance to FMLA and the outcome from these cases. So the first case deals with employer interference in retaliation. In this case, it's titled Schultz v. Advocate Health and Hospitals Corp. In 2000, Chris Schultz, a maintenance employee at Christ Hospital Medical Center, requested and was approved to take intermittent family and medical leave to care for his mother who had a congestive heart problem. Mr. Schultz also needed to care for his father, who happened to have Alzheimer's disease. After his mother passed away in 2000, Mr. Schultz requested to continue intermittent leave to care for his father. During the course of approved intermittent leave, supervisors instituted a new monthly performance policy which graded the amount of work performed in a given period of time. In this case, it was a month. Every month they were graded. Mr. Schultz was rigidly held to the same monthly performance standard, even though he was on approved leave, and then he was fired for not meeting the monthly standard. Mr. Schultz filed suit against Christ Hospital, stating the hospital interfered with his rights under FMLA, and then retaliated against him by discharging him for his use of FMLA's provision. The jury sided with Mr. Schultz and awarded him a sum equivalent to double Mr. Schultz's wage loss. However, Illinois has a state leave law which allows compensation for emotional pain and suffering. The jury then granted a total award of $11.65 million to Mr. Schultz, which included $900,000 judgment against two of the supervisors at the hospital. The hospital, of course, appealed, and in 2006 they provided Mr. Schultz an undisclosed settlement. In the second case, which is the case of LaMonica v. Tread Corp., this case also deals with employer interference and retaliation. Valerie LaMonica began working for Tread Corporation in 2000. In 2013, she was promoted to the HR director. In April of 2014, LaMonica was suffering with emotional issues from being exposed to stress at both work and home. On April 11, 2014, LaMonica met with the CEO of TRED to discuss issues that had arisen out of a lawsuit that was happening. It had been filed against 2 former members of TRED's executive team. During the conversation, both LaMonica and TRED dispute what it was actually stated. LaMonica stated that she told her CEO she was considering resigning, and that her CEO told her to take some time off to think about it, but if she was going to resign, she would need to do so in writing. LaMonica's CEO maintained that LaMonica had resigned during that actual meeting. So during the course of the weekend, several text messages followed between TRED's CEO and LaMonica. In those messages, LaMonica's CEO asked her if she was going to be resigning. LaMonica did not respond to the initial text messages, but then responded that she was not, in fact, resigning, and that she was going to be needing FMLA forms to take to her doctor the following Monday, as she was suffering from emotional distress at that time. On Monday, her doctor recommended a 30-day leave of absence. LaMonica was terminated by email later that day. LaMonica sued TRED Corporation for claims of both interference with her medical leave rights and retaliation. The court found in favor of LaMonica for her interference claim, as LaMonica had provided sufficient evidence that she suffered from a serious medical condition, and she provided sufficient notice of her need for leave. LaMonica also won her claim of retaliation, as her employer took adverse employment action against her while she engaged in a protected activity, and it was determined that her employer fired her because she exercised or attempted to exercise her rights under FMLA. The court awarded LaMonica back pay in the amount of $54,469 and also awarded attorney's fees and litigation costs in the amount of $209,759.69. In conclusion, it is important to remember that since signed into law, the FMLA is the only piece of federal legislation specifically focused on helping workers manage both their responsibilities at work and at home. And while there are federal requirements, these are the set minimum. Other states may have laws that are more advantageous for the employee, and those would apply over the federal minimum. The FMLA is fully enforceable, and employers need to ensure that they are being compliant with the law. Overall, the FMLA is assurance of valuable job protection for eligible employees. Thank you for listening to my presentation today.